Okay, time to get into the filings in the United States v. Comey case page by page. Yesterday, I did some recording and a little bit the day before, and those videos wound up being some shorter clips. One of them has to do with Comey's motion to dismiss for fundamental ambiguity of the questions and that Cruz asked him, and the literal truth. And I used my thread plus some other sources to make about a 40-minute video, which I uploaded to my sites. And then I also did about a 15-minute video that is based on Comey's motion for disclosure of grand jury materials. I tried to make those as quick as I could, like time-wise, how long the videos last. But I didn't go through those filings page by page. Since making those and like kind of throughout the day yesterday, more filings hit the Comey docket. It was a very busy Monday, and the government has finally stepped up and responded to what I characterized as the body shots and headshots from a boxer onto a covered up Lindsay Halligan. You know, it's an imperfect analogy to think of boxing and lawfare here, but what I was trying to say is that this docket has been filled with motions filed by almost entirely Comey's side, and then friends of the court, amicus briefs that are pro Comey's positions, right? And finally, starting on November 3rd, and I think maybe even on a little bit on Sunday, there was one by USA. Yeah, on Sunday, there was one by USA. The government started responding. Prosecutors started responding and filing some big motions. And those motions are really interesting. They're worth a read page by page, and they're also very compelling. And while some of my audience may have been, I think a lot of my audience disagrees with my assessment of Comey and would rather me be sitting here saying, oh, Comey's going down, or kind of taking that attitude about it and conveying that kind of a message. I think you'll find that these motions have shifted me. Especially the one on the appointment of Lindsay Halligan. I find it very compelling, and it's basically changed my mind. Or at least I don't know if I'm ready to say it's changed my mind, but I'm close to saying it's changed my mind on the legality of her appointment. So what I'm about to start doing, this is the first recording of a series of ones I'm going to do that go through these filings page by page. Some are short, but some are pretty long. Before we get to the government's ones, there are I think there's one or two from Comey. There's two from Comey that we're gonna read through page by page. And if you want a shorter version of some of these, well, my YouTube page and my Rumble page has the shorter versions. This is going to be the long version, and this is what's going to go into my main podcast. So welcome all you document nerds. This is where we get into the documents page by page. All right, first thing that I want to make you aware of. Things are going to get just a little bit more confusing than they have been with this case because a third judge has been brought in to handle some of the issues. This is going to be Judge William E. Fitzpatrick, and he is going to handle the motions that have to do with the implementation of a filter protocol. There's going to be a hearing on that tomorrow. As of this recording, it's going to be Wednesday, November 5th. There's supposed to be a hearing on this issue, and it's going to be about the protected material that they're discussing and the quarantine material, and then he's going to hear from both parties on the subject of implementation of a filter protocol. So we have Judge Nachmanov is the Eastern District of Virginia judge who is handling the criminal case. He's going to handle the trial and motions having to do with the trial and all of that. And then there's Judge Curry. I don't know if his name is like two last names, McGowan Curry. So I don't know if it's supposed to be Judge McGowan Curry or Judge Curry. I'm not, it's right there. Judge Cameron McGowan Curry. So I don't know. It's not hyphenated. So I don't really know. So I'm assuming it's McGowan Curry. Anyway, that's a senior South Carolina judge who's brought in to handle the motions that have to do with the legality or the questions of Lindsay Halligan's appointment. He's handling those. and then Judge Fitzpatrick, which forgive me if I call him Fitzgerald sometimes or something, because Fitzpatrick, every time I say Fitzpatrick, I think of Comey's defense counsel. This guy's been brought in to handle motions having to do with the implementation of a filter protocol. So we have 3 judges to keep up with as regards this case so far. Okay. Comey's motion and memorandum in support of dismissal. This is the one that has to do with Cruz's questions being ambiguous and Comey's answers literally being true answers. I'm going to read this word for word without giving a lot of commentary. I already did, like I said, I already did a shorter video that's about 40 minutes long of me including other sources and video and all of those things. But I wanted to do a video where I went through this page by page. Okay. As explained in the accompanying memorandum, Count 1 seeks to punish Mr. Comey for responding to Senator Ted Cruz's fundamentally ambiguous questions with literally true answers. As a matter of law, neither those questions nor those answers can serve as the basis for a violation of 18 U.S.C. 1001A2. Thus, under long-standing principles of criminal law, Count 1 must be dismissed. If Count 2 rests on the same allegedly false statements, it should be dismissed for the same reasons. And in any event, Count 2 should be dismissed because it fails to give Mr. Comey adequate notice of the charges against him. Meaning that Count 2 doesn't explain what the obstruction was. It doesn't have any factual information that characterizes how he obstructed, what the specific investigation was that he obstructed. There's no information. Count 1 of the indictment seeks to punish Mr. Comey for seconds of testimony he gave in response to compound and ambiguous questioning. But longstanding principles of criminal law make clear that the government cannot prove a violation of 18 U.S.C. 1001A2 unless it establishes that the defendant gave false answers to precise questions. Here, the indictment conspicuously omits the lengthy, confusing questions that prompted Mr. Comey's testimony. Specifically, after speaking for more than a minute, Senator Ted Cruz asked Comey to recall statements that he had made 3 years earlier and to simultaneously address statements that Senator Cruz incorrectly claimed were made by Andrew McCabe, the former deputy director of the FBI. In doing so, Senator Cruz never indicated that he wanted Mr. Comey to address the statements or activities of any person except for Mr. McCabe. Viewed in context, Senator Cruz's questions cannot form the basis for a violation of Section 1001A2 because they were fundamentally ambiguous, and regardless, Mr. Comey's answers to them were literally true. Count 1 thus must be dismissed under Federal Criminal Procedure 12B3A, and Count 2 should be dismissed for the same reason, to the extent it rests on those same alleged false statements, and for the independent reason that it deprives Mr. Comey of his right to notice the charge against him. Background. On September 4th, 2013 to May 9th, 2017, Mr. Comey served as a director of the FBI. As FBI director, Mr. Comey oversaw the FBI's operations, including investigations into national security threats and federal crimes involving terrorism, fraud, political corruption, gang violence, and cybercrimes. Among the many investigations at the FBI during Mr. Comey's tenure was Crossfire Hurricane, a counterintelligence investigation into alleged links between President Trump's 2016 campaign, not President Trump, and the Russian government, as well as the mid-year exam, an investigation begun in 2015 into then-candidate Hillary Clinton's alleged mishandling of classified information during her tenure as Secretary of State. On May 3, 2017, Mr. Comey voluntarily testified at the Senate Judiciary's Committee on Annual FBI Oversight Hearing. And then it links to the oversight hearing. As relevant here, Mr. Comey engaged in the following exchange with Senator Charles Grassley. Mr. Grassley: Director Comey, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? Never. Question 2. Relatively related. Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation? No. 3 years later, on September 30th, 2020, Mr. Comey voluntarily appeared before the same committee at a hearing on the Crossfire Hurricane investigation. Then it links to that hearing. As relevant here, Mr. Comey engaged in the following exchange with Senator Ted Cruz. Senator Cruz. On May 3rd, 2017, in this committee, Chairman Grassley asked you point blank, quote, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? You responded under oath, never. He then asked you, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration? You responded, no. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying, and what you testified to, this committee cannot both be true. One or the other is false. Who's telling the truth? Mr. Comey replied, I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017. So your testimony is you've never authorized anyone to leak. And Mr. McCabe, when he says contrary, is not telling the truth. Is that correct? Again, I'm not going to characterize Andy's testimony, but mine is the same today. And then it links to those. The video clip and then the transcript are both filed as sealed exhibits. Or not sealed exhibits, as exhibits. The colloquy thus reflects that Senator Cruz's questions focused exclusively on an asserted contradiction between Mr. McCabe and Mr. Comey. Footnote: compounding the ambiguity, Senator Cruz mischaracterized Mr. McCabe's actual statements in claiming a contradiction between Mr. McCabe's account and Mr. Comey's testimony. There is no record of Mr. McCabe ever stating that Comey authorized him to leak information to the Wall Street Journal, much less a record of repeated and public statements to that effect. Mr. McCabe was interviewed multiple times, and in none of those interviews did Mr. McCabe assert that he spoke in advance with Mr. Comey about his disclosure to the Wall Street Journal. Let me make sure that footnote doesn't continue. Yeah, it does. Rather, Mr. McCabe stated in his last interview that he informed Mr. Comey that he had leaked information after he had done so. Office of the Inspector General report, which we've gone through previously on this show. Indeed, more than 2 years before the hearing with Cruz and Comey, the DOJ's IG found that Mr. McCabe did not consult Mr. Comey before talking to news outlets. Back to the motion. Apparently, based on that testimony, the government has charged Mr. Comey with a 2-count indictment. Count 1 charges Mr. Comey with making false statements to Congress in alleged violation of 18 U.S.C. 1001A2. To prove that a defendant violated 1001A2, the government must establish 1, the defendant made a false statement to a government agency. 2, the defendant acted willfully or knowingly or willfully. And 3, the false statement was material to a matter within the jurisdiction of the agency. Here, the government attempts to satisfy those elements by alleging the following from the indictment. On or about September 30th, 2020, in the Eastern District of Virginia, the defendant, James B. Comey Jr., did willfully and knowingly make a materially false, fictitious, and fraudulent statement in a matter within the jurisdiction of the legislative branch of the government of the United States by falsely stating to a U.S. senator during a Senate Judiciary Committee hearing that he, James Comey, had not, quote, authorized someone else at the FBI to be an anonymous source in news reports regarding an FBI investigation concerning person 1, Hillary Clinton. That statement was false because, as James B. Comey knew then and there, he, in fact, had authorized person 3 to serve as an anonymous source in news reports regarding an FBI investigation concerning person 1. On October 15th, 2025, the government confirmed to the defense that person 1 refers to Hillary Clinton and person 3 refers to Daniel Richman. Additionally, although the indictment does not specifically reference Senator Cruz, Mr. Comey's exchange with Senator Cruz is the only part of the 2017 hearing that touched on whether Mr. Comey had authorized someone else at the FBI to be an anonymous source on news reports. Count 2 charges Mr. Comey with corruptly endeavoring to influence, obstruct, and impede a Senate Judiciary Committee investigation on or about the same date by making false and misleading statements before that committee in alleged violation of 18 U.S.C. 1505. The indictment does not specify which false and misleading statements Mr. Comey allegedly made and why they were allegedly false or misleading. Similarly, the indictment does not specify how Mr. Comey allegedly corruptly endeavored to influence, obstruct, and impede the committee's investigation, or even which investigation that was. All right, argument. Section 1001A2 authorizes the government to prosecute witnesses who mislead government investigators by giving materially false answers to clear questions. But it does not authorize the government to create confusion by posing an imprecise question and then seek to exploit that confusion by placing an after-the-fact nefarious interpretation on the ensuing benign answer. Indeed, basic due process principles in criminal law require that the questioner frame his questions with clarity so that the witness does not have to guess. Quote, the burden is on the questioner to pin the witness down to the specific object of the questioner's inquiry. See Bronston v. United States, 1973. Accordingly, precise questioning is imperative as a predicate for the offense of perjury, and a perjury status cannot be invoked so long as the witness speaks the literal truth. Applying those principles here, count 1 must be dismissed. Count 1 alleges that Mr. Comey made a false statement in response to Senator Cruz's questions at a 2020 Senate hearing. But those questions, which require Mr. Comey to recall statements he had made 3 years prior and simultaneously address another individual's alleged statements, were, quote, fundamentally ambiguous, and thus cannot support a conviction under Section 1001A2, nor can Mr. Comey's literally true answers to those questions support a conviction. Fundamental to any false statement charge are both clear questions and false answers. Neither exist here. In turn, Section 1505 authorizes the government to prosecute a witness who, quote, corruptly or by threats or force, or by any threatening letter or communication influences, obstructs, or impedes a pending proceeding before a congressional committee. As noted, Count 2 alleges that Mr. Comey violated Section 1505 by making false and misleading statements to the Senate Judiciary Committee, but fails to specify which statements were allegedly false and misleading. To the extent Count 2 rests on the allegedly false statements as Count 1, it should be dismissed for the same reasons. And in any event, Count 2 should be dismissed because it fails to give Mr. Comey adequate notice of the charges against him. In answer to a fundamentally ambiguous question, this is the next section, Count 1 must be dismissed because it rests on particular interpretation of fundamentally ambiguous questions. An answer to a fundamentally ambiguous question may not, as a matter of law, form the basis for a false statement under Section 1001A2. See Mosby and citing Sawari. Those are precedent cases. Quote, the purpose of the rule of fundamental ambiguity is threefold, namely to 1, preclude convictions grounded on surmise or conjecture, 2, prevent witnesses from unfairly being the risk or bearing the risk of inadequate examination, and 3, encourage witnesses to testify, or at least not discourage them from doing so. See United States v. Farmer, 1998. To achieve those goals, courts have required near absolute clarity from the questioner in order to support a perjury charge, and have similarly applied that requirement to analogous false statements charges such as those here, United States v. Strom, 2011. Also, United States v. Elfenbein, 2025, which explains that where relevant language is fundamentally ambiguous, a false statement conviction is impossible. A false statement charge that rests on a particular interpretation of a fundamentally ambiguous question must be dismissed. Whether a predicate question is, quote, fundamentally ambiguous is a question of law for the court to resolve before trial. See United States v. Chujoy, 2016. And then United States v. Ryan, 1987, abrogated on other grounds by United States v. Wells, 1997. Those explain that the question is fundamentally ambiguous. If it is fundamentally ambiguous, it is not amenable to jury interpretation, which that's important. This is not a question for the jury to decide. It's for the court to decide before trial. And if a court decides that the predicate question is fundamentally ambiguous, the charge must be dismissed if it does not allege that the defendant's answer was false under every interpretation of the question. See United States v. Serafini, 1999. Senator Cruz's questions at the 2020 Senate hearing were fundamentally ambiguous. A question is fundamentally ambiguous if there are multiple ways to interpret it, and men of ordinary intellect would not agree on which interpretation is correct. For instance, courts regularly deem compound questions fundamentally ambiguous when they make it difficult for a witness to tell which part of the question he should respond to. See United States v. Landau, 1990, United States v. Rendon Marcus, 1999. Other factors that bear on whether a question is fundamentally ambiguous include, quote, the context of the question and answer, and inherent vagueness of certain words and phrases, and defects in syntax or grammar in question, or in a question. Senator Cruz's questions are fundamentally ambiguous because people of ordinary intellect would not be expected to understand that he meant to ask a broad question about Mr. Comey's interactions with anyone at the FBI, including Daniel Richmond, during a colloquy focused on Mr. McCabe. On the contrary, a reasonable person readily would have understood Senator Cruz to be asking only whether Mr. Comey had specifically authorized Mr. McCabe to be an anonymous source in news reports. 1. Senator Cruz's imprecise compound questions make it unclear whether he was asking about Mr. McCabe or FBI officials more broadly. When a government official combines two or more discrete inquiries in one question, but elicits a single response from the witness, it may be impossible to know which question the witness believed he was answering. That is exactly what Senator Cruz did at the 2020 Senate hearing. As relevant here, Senator Cruz asked Mr. Comey two questions, each of which contained a discrete inquiry about Mr. McCabe and a discrete inquiry about FBI officials more broadly. As a prelude to his first question, Senator Cruz described the 2017 exchange between Mr. Comey and Senator Grassley. On May 3rd, 2017, in this committee, Cruz said, Grassley asked you point blank, quote, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? You responded under oath, never. He then asked you, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration? You responded again under oath, no. Senator Cruz did not stop and ask Mr. Comey whether his statements to Senator Grassley were true. Instead, he continued on to describe a statement by Mr. McCabe. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. He then asked, who's telling the truth? By structuring his question that way, Senator Cruz raised two issues. One, whether Mr. Comey was telling the truth in his 2017 exchange with Senator Grassley. And two, whether Mr. McCabe was telling the truth in what Senator Cruz incorrectly characterized as Mr. McCabe's recent statements. But instead of asking Mr. Comey to address each of those issues separately, he only asked Mr. Comey to address the question of whether Mr. Comey or Mr. McCabe was telling the truth. The compound structure of Senator Cruz's question, his second question, was nearly identical to the first. After Mr. Comey responded to the first question, Senator Cruz stated, quote, "So your testimony is you've never authorized anyone to leak?" Senator Cruz then paused and, after a moment, proceeded to ask a question. "And Mr. McCabe, when he says contrary, is not telling the truth. Is that correct?" By structuring his comment and question that way, Senator Cruz signaled to Mr. Comey that he should specifically address the question about whether Mr. McCabe was lying. By the way, I got to pause because I just want to really I pointed this out in my other video, but because Cruz references that exchange with Grassley, I think a lot of people, when they listen to that exchange, they take Cruz to be asking the same question as Grassley did when Cruz wasn't at all. It's just a kind of a funny thing about the way we communicate. And I don't think it's has anything to do with people being unreasonable or being of poor intellect or anything like that. I think it's just the way we communicate and the juxtaposition of Cruz citing a set of questions that were already asked of Comey years before. Oops. Just jumped a bunch of sections on the paper by I hit a button on my keyboard. I think it's just the way we communicate, and people hearing that first part and those questions to Comey sticking in their mind, and then Cruz asking his own questions about Comey. So there's this juxtaposition of two different sets of inquiries, and people come away with thinking Comey's answer covers both sets of inquiries or something like that. And I think it's really easy to get confused like that. And it's a very human and forgivable thing. But when it comes to matters of law and charging someone for a false statement, as we've read in the case law that's been cited here, and the motion is arguing, you need clear questions of someone in order to succeed in prosecuting them with a false statement. It has to be clear questions and clear answers in order for it to be perjury or a false statement. And by the way, that's regardless of who the defendant is. Picture yourself as a defendant, and you get asked some questions by an officer, by an FBI agent or somebody, and you've been charged with lying to law enforcement. You damn sure would want those questions to have been absolutely clear. You don't want it to be a perjury trap. You don't want it to be 3 questions loaded into one, and then they ask you something at the end and you say no, and then they charge you for lying about the second question in a series of 3 when you were only answering the third question, right? And that's kind of what's happening here, is that there's a recounting of previous questions and answers, and then compound questions from Cruz that are ambiguous about they're about a specific person. And yet the indictment charges him with lying in testimony that's past the statute of limitations. But the indictment cites September 30th of 2020 as the day Comey made the false statement. But in their heads, everybody's thinking Comey lied back in May. See what I'm saying? It's like they've put that test. It's like the statute of limitations expired back in May, and then they've put that within this question here. Hope that makes sense. It is like convoluted, and that's the problem. The problem is it's convoluted, and it's ambiguous, and it's, furthermore, Comey said the literal truth. He stood by his testimony. Okay, back to this filing. Courts have regularly determined that similar compound questions are fundamentally ambiguous. In Landau, for instance, the government had asked the defendant, a general contractor whose work for a company had been delayed due to union picketing, whether he had told the company or its representatives that he, quote, had to make payments to the union or that it was necessary because of the union's picketing that it cost you more money, end quote. The court held that the question was fundamentally ambiguous because it compounded two separate inquiries. One, whether the payments to the union were necessary and whether the picketing cost more money, and elicited a singular response. Accordingly, the court concluded that the question could not, as a matter of law, support a perjury conviction and dismissed the indictment. Now, how much less ambiguous and confusing is that question than what Cruz was asking Comey? Like, that is so much less ambiguous and convoluted than this set of questions from Cruz to Comey were. And yet this was dismissed. Similarly, in Rendon Marquez, the court determined that the following question on an Immigration and Naturalization Service form was too ambiguous to support a conviction under Section 1001, the same section Comey's charged with. Quote, have you knowingly committed any crime or offense for which you have not been arrested, or have you been arrested, cited, charged, indicted, convicted, or fined or imprisoned for breaking or violating any law or ordinance, including traffic violations? The court explained that the form, quote, asked two separate and distinct questions, but provided space for only one yes or no answer. So it could be, have you knowingly committed any crime or offense for which you have not been arrested? That's one question. And then the second question is, have you been arrested, cited, charged, et cetera, including traffic violations? Because it could be this one, but not this one, right? Or it could be this. Yeah, you could say yes to one and no to the other. Likewise, each of Senator Cruz's questions compounded two separate inquiries: whether Mr. Comey was telling the truth in 2017, and whether Mr. Comey had authorized Mr. McCabe to be an anonymous source, but asked for the equivalent of a yes or no response only as to the second inquiry. Any reasonable witness would not have found it difficult to know that Senator Cruz wanted Mr. Comey to answer the binary question just asked, and also to address the prior comments. This is especially so where the questioner did not confront Mr. Comey with what the government is now claiming he then and there knew, which is the alleged conduct involving Mr. Richmond, but instead confronted Comey with an inaccurate account of Mr. McCabe's statements. Everything about the exchange narrows it to being focused on McCabe, and that Senator Cruz was inquiring about McCabe. Next part, 2. Senator Cruz's use of alternating narrow and broad questions reinforces that the line of questioning was fundamentally ambiguous. Even if Senator Cruz's use of compound questions did not by itself make those questions fundamentally ambiguous, context confirms that Mr. Comey could not have reasonably known that Senator Cruz was asking him to answer a broad question about anyone at the FBI when asked a specific question about Mr. McCabe. As noted, the context of the question and answer can establish that a witness could not have understood what he was being asked. Accordingly, the court must look to the context of the defendant's statement to determine whether the defendant and his questioner joined issue on a matter of material fact, to which the defendant allegedly uttered a false material declaration. As relevant here, context can establish that a defendant would have understood a facially broad question to have a much narrower focus. The Third Circuit's decision in Serafini, which affirmed the district court's pretrial dismissal of a perjury charge, is instructive. As part of an investigation into that's going to give an example here. As part of an investigation into a suspected campaign finance violation, the government asked the defendant a series of 3 questions about a $2,000 check he had received from his nephew, ostensibly as a reimbursement for his $1,000 donation to Bob Dole's presidential campaign. Question 1, is there any check that you received that reimbursed you other than the $2,000 check for your contribution? No. Is there another check that you were aware of that is connected to this investigation, to this Dole contribution, other than the $2,000? Answer, not other than what you have shown me today. No. Question 3. Did you receive any other money, whether by cash or check or any other form, from Michael at or around the time period you made your Dole contribution other than this $2,000 check? Answer, I can't specifically remember. However, we transfer money back and forth quite often for different reasons, and I can't honestly say that there wasn't some kind of transfer. I mean, we do it all the time. After discovering that the $2,000 had served to reimburse both the defendant and his aide for respective $1,000 contributions, the government charged the defendant with making a false statement in response to question 2. The government claimed that question 2 had asked the defendant to identify any other check he was aware of, and that he had been aware of at least 2 others: the aide's check to the campaign and his check reimbursing the aide. The Third Circuit held that question 2 was fundamentally ambiguous because, quote, read in context, the question takes on a particular meaning wholly at odds with the broad, open-ended significance the government now seeks to attribute to it. The court explained that although question 2 could in isolation be interpreted as asking whether the defendant was aware of any other checks, the government's antecedent and subsequent questions focused on whether the defendant had personally received any other reimbursement checks. Given the narrow subject matter of those questions, the court explained, the defendant could easily have interpreted the sandwich question, question 2, to ask whether he had personally received other checks from his nephew besides the $2,000 check. Indeed, the best way for the defendant to, quote, inject into the question sufficient intelligibility so that he could reply was to treat the question as referentially sequential to questions he had just answered. Context thus showed that the defendant would not have understood the question to have the limitlessly capacious construction the government would have it bear. Context shows that the question at issue here in United States v. Comey were even more ambiguous and unfair than those in the case of Serafini, as Mr. Comey was expressly invited to answer only the narrower questions. As explained above, Senator Cruz began by summarizing Mr. Comey's response to Senator Grassley's broad question about whether Mr. Comey had, quote, ever authorized someone else at the FBI to be an anonymous source in news reports. But Senator Cruz then narrowed his focus, incorrectly asserting that, quote, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Accordingly, when Senator Cruz asked Mr. Comey to address who's telling the truth, the best and perhaps only way for Mr. Comey to inject into the question sufficient intelligibility so that he could reply was to, quote, treat the question as referentially sequential to Senator Cruz's immediately antecedent assertion about Mr. McCabe. In other words, a reasonable witness most readily would have understood Senator Cruz to be asking him to specifically address whether he had authorized Mr. McCabe to serve as a source to the Wall Street Journal. Similarly, although Senator Cruz began a second question by referencing Mr. Comey's general statement that he had, quote, never authorized anyone to leak, he again narrowed his focus, asking, quote, and Mr. McCabe, if he says contrary, is not telling the truth, is that correct? Context thus underscores that count 1 rests on a fundamentally ambiguous question. As the indictment frames it, Senator Cruz's question was whether Mr. Comey had, quote, authorized someone else at the FBI to be an anonymous source in news reports. But that quoted language is taken from a statement by Senator Cruz that is a preface to the question that followed 4 seconds later. When fairly read in context, the question takes on a particular meaning wholly at odds with the broad, open-ended significance the government now seeks to attribute to it. Specifically, that context suggests that Senator Cruz was asking only about whether Mr. Comey had authorized Mr. McCabe to be an anonymous source to the Wall Street Journal. Pause. I gotta say, it even takes on a little bit more of that characteristic when you know that Mr. McCabe had been found guilty, or not found guilty, had been found at fault just 2 years prior to this, specifically for leaking to the Wall Street Journal anonymously through Lisa Page for this article right here from October 30th, 2016. And he had lied about it multiple times. He lied to Comey about it. He lied to INSD investigators about it. And he lied to the IG about it. And he got caught because IG Horowitz got Lisa Page's text messages and proved it, that McCabe had been the source of the leaks in this article, and he had made them anonymous, used Lisa Page as an intermediary. And we went through that on a previous episode. But knowing that, when Cruz is asking about Mr. McCabe being an anonymous source to the Wall Street Journal, what comes to mind? This article. And Comey, in the first week of November 2016, had specifically asked McCabe about this article and who leaked to it, and McCabe pretended not to know. So all of that information just colors in that in the moment of this line of questioning from Cruz, it makes even more sense that Comey is going to understand Cruz to be specifically asking about this instance of this article, which was investigated and already figured out 2 years prior that McCabe did it on his own. Part 3. Senator Cruz's questions were riddled with other ambiguities that would have made it difficult for any reasonable person to understand them. Senator Cruz's focus on Mr. McCabe is alone sufficient to establish fundamental ambiguity when measured against the government's current interpretation. But there is more. Senator Cruz's questions were riddled with other ambiguities that would have made it difficult for any reasonable person to understand them in the moment. For instance, Senator Cruz asked Mr. Comey to affirm or deny prior testimony that he authorized, quote, someone else at the FBI to be an anonymous source of news reports about the Trump investigation or the Clinton administration. As of May 3rd, 2017, there was no Trump investigation, but rather than an investigation into whether there were links between 4 individuals associated with the Trump presidential campaign and Russia, as I've been telling you guys for years and years and years. I've been telling you for years and years. Oh, that exact thing. Let's see, what are these footnotes? Oh yeah, it adds that Mr. Comey voluntarily agreed to testify at this particular hearing on the understanding that the topics of questioning would be limited to 4 topics, none of which related to the mid-year exam investigation involving Hillary, which isn't that big of a deal, but it's worth pointing out that they sent Comey the 4 topics they were going to be talking about this hearing, and then they ended up asking him about other things. All right. And the Clinton investigation, the Clinton administration had ceased to exist some 17 years before. Senator Grassley's original question in 2017 was about the Clinton investigation, not the administration. Senator Cruz's use of the words never and ever injected additional ambiguity. Courts have explained that questions asking witnesses to recall whether they ever have done something are ambiguous because it is difficult to answer them without a perfect memory. See United States v. Zaya, 1973. Questioners can avoid such ambiguities by focusing the witness's attention on a particular day or time, which in a sense Cruz did because he focused him on McCabe and Wall Street Journal, right? Accordingly, when Senator Cruz referenced Senator Grassley's question asking whether Mr. Comey had ever authorized someone else at the FBI to be an anonymous source in news reports, he made it even more difficult for Mr. Comey to understand what he was asking. Finally, when Senator Cruz referenced Senator Grassley's questions about whether Mr. Comey authorized someone else at the FBI to serve as an anonymous source, there was no reason to assume that he was referring to anyone but full-time employees like Mr. McCabe, who were stationed at the FBI, as opposed to someone like Mr. Richmond, who was a special government employee living full-time in New York. Senator Cruz's errors are a form of imprecision whose consequences must be laid at the table of the questioner, not the questioned. And I don't think this is any small point. Richmond, for a time, was a special government employee hired by Comey, but he wasn't a full-time employee of the FBI. But it kind of doesn't even matter because Cruz didn't ask him about that. Cruz narrowed it to being about McCabe and kept refocusing it on McCabe. And Cruz didn't, like I said earlier, Cruz is not re-asking the questions that Grassley had asked 3 years prior. In order for this indictment to really make sense, Cruz would have needed to be asking or re-asking the same questions that Grassley had. And that's not what happened. He asked him about McCabe specifically. Count 1 rests on a particular interpretation of Senator Cruz's fundamentally ambiguous questions and thus must be dismissed. Persons of ordinary intellect could and likely would have understood Senator Cruz to be asking Mr. Comey whether he authorized Mr. McCabe to serve as an anonymous source to the Wall Street Journal. Thus, because there is no allegation that the question so understood, Mr. Comey's answer was false. Count 1 should be stricken. The indictment alleges that Mr. Comey's statement was false because he, in fact, had authorized Person 3 to serve as an anonymous source in news reports regarding an FBI investigation concerning Person 1. On October 15, 2025, the government confirmed to the defense that Person 3 refers to Daniel Richmond and Person 1 refers to Hillary Clinton. But as noted, a reasonable person could have understood Senator Cruz's questions to be entirely unrelated to Mr. Richmond or anyone else at the FBI, and to have focused on Mr. McCabe alone. On that reasonable understanding, the indictment contains no allegation that Mr. Comey's answers were false. It never alleges that Mr. Comey made a false statement regarding Mr. McCabe. On the contrary, the indictment omits Senator Cruz's statements about Mr. McCabe, obscuring the context necessary to understand both the questions themselves and Mr. Comey's responses. The indictment thus impermissibly lifts statements of the accused out of its immediate context and gives it a meaning wholly different than that which in context it clearly shows. As a result, count 1 cannot be sustained. 2. Mr. Comey's literally true answers separately warrant a dismissal of count 1. Regardless of whether Senator Cruz's questions were fundamentally ambiguous, the court should also dismiss count 1 because Mr. Comey's answers were literally true. Where a witness's answer is not responsive to the question asked, it cannot serve as the basis for a false statement's charge if it was literally true under any interpretation of the question. See United States v. Smith, 2022. Skip part of that citation. Although the literal truth defense is a narrow one, the Fourth Circuit has dismissed numerous perjury and related charges based on a defendant's literally true answers. And it gives a bunch of examples here, which I'm going to skip, but it cites a bunch of ones that were dismissed. Here, Mr. Comey's answers to Senator Cruz's questions were literally true. When Senator Cruz's preliminary statements are omitted from the questions and answers, it is apparent that the senator posed 2 questions to Mr. Comey. The first question was between Mr. Comey and Mr. McCabe. Who's telling the truth? A direct answer to this question would have required Mr. Comey to respond either, I am telling the truth, or Andrew McCabe is telling the truth. Mr. Comey, however, did not respond by stating who was telling the truth. Instead, he stated, quote, I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. Although those statements did not respond directly to Mr. Cruz's question, they were literally true. Mr. Comey could only speak to his own testimony. He could not read Mr. McCabe's mind and know whether Mr. McCabe intentionally lied in the statements described by Senator Cruz. This is all the more true where Senator Cruz cited statements that Mr. McCabe simply had not made. Likewise, Mr. Comey's statements that he stood by his prior testimony was truthful, regardless of whether that prior testimony was itself truthful. The same, which by footnote, Mr. Comey firmly maintains that his prior testimony was truthful, but for purposes of the literal truth defense, the truthfulness of the prior testimony is irrelevant. Mr. Comey can truthfully stand by prior testimony, even if the government were correct, and it is not, that the prior testimony was false. Accordingly, the statement that Mr. Comey stands by his prior testimony cannot serve as the basis for a false statement charge. The same is true of Mr. Comey's answer to Senator Cruz's second question. Senator Cruz asked, quote, so your testimony is you've never authorized anyone to leak, and Mr. McCabe, when he says contrary, is not telling the truth. Is that correct? A direct answer to this question would have required Mr. Comey to state either correct, Andrew McCabe is not telling the truth, or incorrect, Andrew McCabe is telling the truth. Mr. Comey said neither of those things. He instead stated that he was, quote, not going to characterize Andy's testimony, but mine is the same today. Again, that response is literally true. Mr. Comey, in fact, did not characterize Mr. McCabe's testimony, and his statement that his testimony is the same today simply meant that he did not intend to revisit his prior testimony. That was a literally true statement, regardless of whether the prior testimony was itself truthful. Further, as detailed above, Senator Cruz's questions referenced whether Mr. Comey authorized anonymous sources to report on the Trump investigation, which did not exist during his tenure as FBI director, and the Clinton administration, which had ended nearly 17 years earlier. So Mr. Comey's answers to the questions were literally true, and the government cannot incorrectly rewrite his responses to form a false statements charge. Ignoring those details, the government presented an indictment to the grand jury that misstates Mr. Comey's testimony. But if a person cannot be charged by, quote, the device of lifting a statement of the accused out of its immediate context, and thus giving it a meaning wholly different than that which its context clearly shows, he certainly cannot be charged where the statement lifted out of context must be rewritten to claim that it is false. In sum, although Mr. Comey did not respond directly to Senator Cruz's questions, his responses were literally true. Section 1001A2 does not criminalize non-responsive testimony. It criminalizes only false testimony. And Mr. Comey's testimony here cannot plausibly be characterized as false. Of course, Senator Cruz could have followed up by asking for clearer answers, or he could have reframed his initial questioning with greater precision, or Senator Cruz could have asked Mr. Comey about other specific individuals, including Mr. Richmond, but he did not. And that is what the questioner must have done if the government wishes to prosecute the defendant. The questioner must press on for the information he desires. The government cannot now correct his failure by a prosecution for making a false declaration. Accordingly, regardless of whether Senator Cruz's questions were fundamentally ambiguous, Count 1 should be dismissed on the independent basis that Mr. Comey's answers were literally true. Part 3. Count 2 should be dismissed for similar reasons. Count 2 alleges that Mr. Comey violated Section 1505 by making a false or misleading statement to the Senate Judiciary Committee. The indictment does not, however, specify which false and misleading statements Mr. Comey allegedly made, why they were allegedly false or misleading, or even which investigation he allegedly endeavored to corrupt. To the extent Count 2 rests on the same false statements as Count 1, that count should also be dismissed for the reasons set forth herein. But as it stands, count two's lack of specificity renders it inherently and separately defective for failing to provide adequate notice to Mr. Comey of the charge against which he must defend. Such notice is of paramount importance here because of the broad scope of the relevant congressional hearing and the many topics covered in prolonged testimony. The government cannot try Mr. Comey on cherry-picked statements from a 4-hour hearing without specifying which statement it believes is false or misleading. And surely the government does not believe that it may secure an indictment based on one statement placed before the grand jury and then switch to a different statement at trial. That tactic would defeat the purpose of the grand jury performing its charging function. It also provides yet another reason for the disclosure of the grand jury proceedings, which is another motion they filed. And it is further basis to grant Mr. Comey's concurrently filed motion for a bill of particulars, which we're going to read next, I think. Accordingly, the lack of specificity in count 2 deprives Mr. Comey of his right to notice of the charge against him, and that count is subject to dismissal on that deficiency alone. Conclusion: for the foregoing reasons, the indictment should be dismissed with prejudice. I think that's a very compelling filing, and I don't really know how the government gets around that, how the prosecution is going to square this. But I look forward to reading their filing that attempts to do so and seeing if I'm persuaded by it. Could happen.